A very good morning to all my dear students and listeners. Today we are going to discuss about the drafting of will under the subject captioned as drafting, pleading and convention. But before starting with the today's topic, that is the drafting of will deed, I would like to explain you the meaning and the concept behind making a will. My dear students, as you all are aware that will is the legal instrument whereby a person declares what is to be done with his property after his death, meaning thereby in will a person explains or declares about the devolution of his property after his death, meaning thereby to whom the said property to be devolved upon after his death. Further, it means the declaration of the intention of the testator with respect to his property which he desires to be carried into effect after his death. This was so explained or defined under Section 2 Clause H of Indian or Hindu Wills Act 1870 and also under Section 2H of Indian Succession Act and Section 3 of the Hindu Wills Act. This will shall include a codicil and every writing making a voluntary posthumous disposition of property. This was so explained under Section 3 Clause 57 of General Clauses Act 1897. Further, my dear students, while drafting a will, one must keep in mind that who can be a party to the will, or meaning thereby who can make a will. As far as the law on this point is concerned, it is submitted that every person who is of sound mind but may not be a minor can dispose of his property by will. Further, a married woman may dispose by will of any property which she could alienate by her own act during will. As you all are aware that before the enactment of Hindu Succession Act, the woman can hold the property only as a limited owner, and by virtue of Section 14 of Hindu Succession Act, she was given an absolute right with regard to her Stridhan, and with regard to other property, she would be treated as a limited owner of the said property. Further, a person who are deaf or dumb or blind are not thereby incapacitated for making a will if they are able to know what they do by it, meaning thereby a person who is of deaf or dumb or blind may also make a will, but they must be clear about what they do by it. Further, there is another important term which needs to be read along with the will is the term of codicil. As far as the word codicil is concerned, the same has been defined under Section 2B of Indian Succession Act, wherein it provides that or means an instrument made in relation to a will and explaining, altering or adding to its disposition and shall be deemed to form part of the will. This word codicil is derived from the Roman word codicillus, meaning an informal will. According to the definition, three things are evident: that a codicil cannot be oral, but there must be an instrument. That means it must be in writing. Second, it must have made in relation to a will which has already come into existence. And third, that its object is to explain, alter, add to the disposition under the will. Now I would like to explain you the purpose of the codicil. The purpose of the codicil is to make some slight changes in a will which has already been executed. Though major alterations will not invalidate its dispositions. Now, what are the essentials of a will? Meaning thereby, what are the points to be considered while drafting a will? The following essential needs to be satisfied. Number one, there must be a legal declaration of testator's intention. Number two, that the declaration must be with regard to his property and the desire of the testator, that is the person who makes the will, and that the said declaration should be effectuated after his death and must also be there. Now I would like to explain the word testament. The word will in English corresponds to the expression testament, meaning testio mentis or determination of mind. It is the translation of the Latin word voluntas, which was used by the Romans to express the intention of the testator. Now, I would like to give you the important points to be taken into consideration for proper execution of the will. Number one, that the testator must have a disposing mind free from all extraneous influences with sound mental health or mental mind. Clause B, that the testator is presumed to be sane, having a mental capacity to make a will until contrary is proved. Further, the will should be executed in accordance with the provisions of the Act as incorporated in Section 63 of Indian Succession Act, read with Section 67 and 68 of the Evidence Act. So from this, we may infer that there is an interplay between the provisions of Indian Succession Act as well as Indian Evidence Act. Further, the onus of the proof of the will is on the propounder or the beneficiary of the will. Further, the existence of suspicious circumstances make the onus of proof very heavy, and such circumstances are required to be removed by the propounder before the document is accepted as the last will of the testator. Further, the mode of serving the will does not ordinarily differ from that of proving any other document except under the special circumstances as provided under Section 63 of Indian Succession Act. Further, in order to ascertain the free disposing mind, free from extraneous consideration, the whole of the attending circumstances in a particular case are required to be taken note of it. This was so held in the case of Shrimati Bhagyavati versus General Public, 1994, 1, Haryana Law Reports, 398, Punjab and Haryana High Court. So my dear students, this is all about the concept, meaning, and the nature and the essentials of will deed. Now, in this background, we are now going to start with the drafting of the will. As you all are aware that the components of the deed includes that there must be a description of the deed. So at the heading, you may put that this is a will deed. Thereafter, you have to give the date. At the right hand side, you may mention the date on which the said deed is going to be signed or it is to be executed, as the case may be, provided the requirements of Registration Act needs to be satisfied in this regard or taken care of in this regard. Thereafter, we have to explain the parties to the deed. So we have to explain about the person who is making his testament or this will. So this may be written as I, Shri so and so, son of Shri so and so, residing at so and so, aged about so and so, Hindu or Muslim, either as the case may be, by religion, and you may also mention his occupation. Do make this my last will and testament. As you all are aware that one of the essential elements, that this must be the last and the final testament as well. Further, I have not made any will or other testamentary document But if any made, I hereby revoke all previous will and codicils, if any, and declare this to be my last and the final testament, meaning thereby. Here the testator explains that this will needs to be analyzed as his final will and to be taken into consideration by the court while deciding the validity of the said will in case dispute arises before it, and treat this will as his last and the final will. And if he has made any previous will, then the same would be treated as null and void in the eye of law. Now he has to explain the second party. I appoint Shri so and so residing at so and so, aged about so and so, by religion, occupation so and so. Further, Shri so and so residing at so and so, aged about so and so, year by so and so, religion by so and so, and occupation by so and so. So here you have to give the description of the person who has been given benefit under the said will. Thereby you have to give explanation to each and every member of every person so appointed. Thereafter, in his will, you have to explain, or the person who is making the will has to explain all the members of his family, thereby explains the family tree of the person who is making the will or executing the will. Thereafter, property of the executant must also be included in the next paragraph, wherein both movable or immovable or tangible or intangible property may also be put or to be dealt in this will for the distribution or devolution of the same, and the said will would come into force after his death. In next paragraph, you may explain that I bequeath all my property in whatever form existing at the time of my death to the said executor and trustee to hold the same on trust for the benefit of my wife, Srimati so and so, for her lifetime until her death, as herein after provided. So in this will, we have treated the devolution on the wife as a limited owner thereof. Further, my executor and trustee shall, after spending the necessary money for the management of the said property, pay the net income to my wife, and the same will belong to her absolutely without liability to account for the same. Meaning thereby, after spending the money on the property, the remaining balance would be treated as absolute property of his wife after his, which would come effect after his death. My executor and trustee will also spend out of the corpus such amounts as may be required by my wife for medical expenses or for pilgrimage, but my executor and trustee will not be entitled to sell my immovable property. So in this case, all the properties, immovable property mentioned herein under, given to the management or to the executor or to the trustees, as the case may be, they would be the limited owner of the said property on the death of my, and if she predeceases me, then on my death, all my estate then existing, whether mentioned in this will or not, will belong to my children absolutely in equal share, and the trustees for a time being of the said estate under this will shall transfer the same among said children by executing proper document or documents, provided that if at the time of the death of my wife or myself, the case may be, any of the said children is a minor, the trustees shall hold the said property on trust until the youngest attains the age of majority. Until then, the net income of the said property will be given or spent for maintenance and education of the said children. Further, my executor and trustee shall obtain the probate of this will from a competent court if required in law, and shall pay all the probate duty and other expenses required for such probate, and also pay at the first charge all my other liabilities by way of taxes or otherwise, howsoever. Further, I have made this will out of my free will when I am in soul, sound health, and in good understanding, and in witness thereof. I have put my signature hereunder in the presence of the witnesses on this day of the month of this so and so in a year, signed by within the named testator, Sri so and so, opposite in the presence of the witnesses. Testator, who in the presence at his request and in the presence of each other have put their signatures as witnesses. I so and so, their full address and would be given herein. So, my dear students, this is how the will may be drafted. In this circumstance, we may conclude that the property would be given to the wife as absolute owner and a note as limited owner, but the property in the hands of the executors and the trustees, as the case may be, they would be treated as the limited owner in this format of the will. Hope you have learnt a lot from this draft of the will or the will deed, as the case may be. If you have any query, my dear students, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on drafting of an agreement to sell, which I am going to take in my next lecture. Till then, thank you very much. We'll meet you very soon in my next lecture. Till then, stay home, stay safe, and stay healthy.